We're on the record in cause number 323788. The case is styled the state of Texas versus Marquise P. O'Neill. We have Mr. Marquise O'Neill appearing via telephone. Mr. O'Neill, how are you doing?
I'm good.
That's good. Now, Mr. O'Neill, you're here represented by your attorney, Mr. Todd LeBlanc. Mr. LeBlanc is appearing via Zoom. Mr. LeBlanc, how are you doing?
Good, Judge. Thanks for asking.
Mr. LeBlanc, do you have an announcement that you would like to make in Mr. O'Neill's case?
Yes, Judge. I've gotten the discovery. I need some time to talk with him and the prosecutor. My client lives in Bryan, Texas, I believe, or at least that's where he is. So I haven't been able to talk to him face to face yet.
Oh, how much time do you need on your reset?
A regular reset, Judge, would be fine.
Okay, just hold on. We'll get that reset to you. Okay. Reset date is going to be June the 2nd of 2021. Mr. O'Neill, your case is being reset to June 2nd of 2021. Please stay in contact with your attorney. This will conclude your case and you're excused. Have a blessed day. Mr. LeBlanc, this is your only case. We will send you your reset. You're excused and you have a blessed day as well.
Thank you, Judge. You too.
Okay. It's June 2nd. Yes. Okay. Let's do this all over. Okay, we're on the record in cause number 327-152. The case is styled the state of Texas versus Celestial Moss McKenzie. Now, Ms. McKenzie, you have been sworn in, is that correct?
Yes, sir.
And Ms. McKenzie, the information in this case alleges that on or about December 12th of 2019, while you're in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class B misdemeanor offense of driving while intoxicated. Do you understand that?
Yes, sir.
And to that charge, how do you plead? Guilty, not guilty, no contest.
No problem.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Now, Ms. McKenzie, I have before me a document that is titled the Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
And on page 2 of the same document, Ms. McKenzie, are these your initials on the line that says no look injury, which means no contest?
Yes, sir.
Okay, and on the next document, Ms. McKenzie, is that your signature above the line that says defendant at the top?
Yes, sir.
And on the next document, which is trial court certification of the defendant's right of appeal, you recognize this document?
Yes, sir.
And is that your signature above the line that says defendant?
Yes, sir.
There are 2 boxes that's checked at the top of the document. The first box states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you are waiving or giving up your right to appeal. Do you understand that?
Yes, sir.
I have before me another document which is titled discovery certification. Do you recognize this document? And did your attorney, is that your signature on the second line of this document? And did your attorney go over these documents with you?
Yes, sir.
Did you read and understand everything in these documents?
Yes,
Is everything in these documents true and correct to the best of your knowledge?
yes, sir.
State, I have before me states exhibits number 1. State, you like to offer states 1?
Yes, Your Honor, and I'd also like to offer State's Exhibit number 2. That's the probable cause affidavit for this case.
Ms. Provo, do you have any objections? No objection. States exhibits number 1 and 2 are admitted. Ms. Provo, you have advised and counsel. Ms. McKenzie, is there any evidence that she's currently mentally incompetent to stand trial?
No, you don't.
Ms. McKenzie, your attorney, Ms. Provo, has advised and counseled you. Are you satisfied with her representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Okay, Ms. McKenzie, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea of no contest and waivers are freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. Okay. State, do we have a plea bargain agreement?
Yes, Your Honor. The agreement in this case is 1 year deferred probation, a $500 fine, 80 hours community service, the DWI education course, drug and alcohol assessment, and an interlock. And I've reviewed over the case, and it was not a case over 0.15. She does not have a commercial driver's license, and she has no prior DWI convictions. She only has a couple of prior arrests, but no convictions that I could find in her history.
Okay. Now, Ms. McKenzie, the state is offering that you serve 1 year deferred adjudicated probation. During this 1 year probationary period, you'll be required to pay a fine of $500 plus court costs, which comes to a total of which comes to a total of $937. You'll also be required to pay probation fees of $60 each month, a year analysis fee of $15 each month. You'll also be required to reimburse the court-appointed attorney's fees of $250. And You'll be required to pay the Jefferson County DWI education class an initial evaluation fee of $125. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, the total monthly installments in this case will be $185 a month. Ms. McKenzie, would you be able to pay the $185 a month?
Yes, ma'am.
And Ms. McKenzie, you will also be required to perform 80 hours of community service. I don't think you have the other stuff on here. Now, she was also required to attend the DWI education class, is that correct?
Yes, Your Honor. To attend the DWI education class, have a drug and alcohol assessment, and then the interlock.
Okay, so you'll be required to attend the DWI education class, have a drug and alcohol assessment, and you'd have to install an interlock device on any vehicle that you own or operate. Ms. McKenzie, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in this case is fair and just?
Yes, sir.
And Ms. McKenzie, do you accept the state's offer?
Yes, sir.
Okay, Ms. McKenzie, I'll follow the plea bargaining agreement that you've entered into with the state, and pursuant to Article 42A.108, I must inform you orally the possible consequences under 42A.108 and 42A.101 of a violation of a condition if deferred adjudicated probation is given. Now, we on the record, again, in cause number 327152, and per Article 42A 108 and 42A 110, the court will be recording as required by the court, and we will maintain a statement to the defendants regarding the consequences of deferred adjudicated probation in a DWI case. Now, pursuant to Article 42A 108, on violation of a condition of deferred adjudication, community supervision imposed under Article 42A 104, defendant may be arrested and detained as provided in Article 42A 751. The defendant is entitled to a hearing limited to the determination by the court of whether the court will proceed with an adjudication of guilt on the original charge. The court may not proceed with adjudication of guilt on the original charge if the court finds that the only evidence supporting that alleged violation of a condition of deferred adjudicated community supervision is the uncorroborated results of a polygraph exam. The determination to proceed with an adjudication of guilt on an original charge is reviewable in the same manner as a revocation hearing conducted under 42A.751D in a case in which the adjudication of guilt was not deferred. A court retains jurisdiction to hold a hearing under Section B and to proceed with an adjudication of guilt, regardless of whether the period of deferred adjudicated community supervision imposed on the defendant has been expired. If before the expiration of the supervision period, one, the attorney representing the state files a motion to proceed with the adjudication of guilt, and two, a capus is issued for the arrest of the defendant. Now, pursuant to Article 42A.110, proceeding after adjudication of guilt, after the adjudication of guilt, all proceedings, including assessment of punishment, pronouncement of sentence, granting of community supervision, and the defendant appeal continues as if adjudication of guilt had not been deferred. A court assessing punishment after adjudication of guilt of a defendant charged with a state jail felony may suspend the imposition of the sentence and place the defendant on community supervision, or may order the sentence to be executed regardless of whether the defendant has previously been convicted. Now, also, Ms. McKenzie, if you successfully complete the probationary period, this case will be dismissed. It will not appear on your record as a conviction, and you may qualify for a non-disclosure. You can talk to your attorney about a non-disclosure. Now, Ms. McKenzie, please stand on X where your attorney is standing. You're going to follow the directions of our court clerk, and once you finish here, you'll be free to go, and you have a blessed day. And you have a blessed day as well, Mr. Provo. Yes. We're on the record in cause number 327554. The case is styled the State of Texas versus Brandon Lee Hockless. We have present in the court, Mr. Hockless. Mr. Hockless, is that your full name?
Yes, sir.
And Mr. Hockless is here represented by his attorney, Mr. Jack Lawrence. Mr. Lawrence, how are you doing?
Just fine, Your Honor.
And Mr. Hockless, how are you doing?
Let's have it.
Okay. Mr. Hockless, would you please raise your right hand? Mr. Hockless, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, Mr. Hockless, you may put your hand down. Okay, now, Mr. Hockless, I have before me an information that alleges on or about July 5th of 2020, while you were in Jefferson County, Texas, you was charged that you committed the offense. It alleges that you committed the Class A misdemeanor offense of family assault, family violence. Mr. Hockless, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Hockless, how do you plead? Guilty, not guilty, no contest?
No contest.
Now, you pleading no contest freely and voluntarily?
Yes, sir. Your Honor, if this is a nolo contendere, no contest, just for the purposes of Texas law. Nolo contendere and no contest differ slightly under Texas law, but this is a nolo contendere, no contest.
Okay, so he's pleading nolo contendere, no contest.
Yes, Your Honor.
Okay. Now, Mr. Hockless, are you pleading nolo contendere, no contest freely and voluntarily?
Yes, sir.
And are you pleading nolo contendere, no contest because you do not wish to fight or contest the charges?
Yes, sir.
All right. Now, Mr. Hockless, I have before me a document that is titled Misdemeanor Plea Admonishments. And on page 1 of this document, which is State's Exhibit number 1, Misdemeanor Plea Admonishments, do you recognize this document? You can stand right here on the X. Do you recognize this document?
Yes, sir.
Now, on page 2 of the same document, on a line that says nolo contendere, are these your initials?
Yes, sir.
And on page 3 of the same document, at the top of this document, above the line that says defendant, is that your signature?
Yes, sir.
And on the next document, which is the trial court certification of defendant's right of appeal, Do you recognize this document?
Yes, sir.
And is that your signature down here on the line that says defendant?
Yes, sir.
There are two boxes that's checked at the top of this document. The first box states that this is a plea bargaining case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
I have another document here, Mr. Hopkins, that is titled the discovery certification. Do you recognize this document?
Yes, sir.
Is that your signature above the line that says defendant on this document?
Yes, sir.
Now, Mr. Hopkins, prior to signing and initialing these documents, did your attorney, Mr. Lawrence, Jack Lawrence, go over these documents with you?
Yes, sir. You went over with me fully.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes, sir.
State, I have before me state's exhibit number 1. State, you like to offer states 2? Number 1?
Yes, Your Honor, I'd like to offer State's Exhibit number 1, and I'd also like to offer State's Exhibit number 2. That's the probable cause affidavit for this case.
Okay, Mr. Lawrence, do you have any objections to the state's offering state's exhibit number 1 and state's exhibit number 2?
I need to read State's Exhibit number 2.
Okay, just hold on. We'll be in recess. Give him opportunity to read it. Hold on a minute. Oh, y'all stated that already.
You have to decide.
If it's unagreed, I know.
Here's the,
Well, hold on. We're gonna give you one at a time. Just, that's the PC affidavit. Just take time to review it, see if you have any objections. Ashley, we're gonna proceed with 2 other cases. We're gonna proceed with Joshua Vincent cases.
Okay,
All right. We're on the record in cause number 324-378-2 and cause number 324-380-2. Both cases are styled the state of Texas versus Joshua Tyler Vincent. Mr. Vincent, is that your full name?
Yes, sir.
Mr. Vincent, would you please raise your right hand? Mr. Vincent, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, Mr. Vincent, you may put your hand down. How you doing, Mr. Vincent?
Doing good. How are you doing?
I'm doing fine, thanks for asking. Mr. Vincent, you're here represented by Antoine Freeman. Mr. Freeman, how you doing?
Good, John, how are you?
I'm doing fine. Mr. Vincent, information in this case alleges that on or about September 2nd of 2019, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of burglary of a vehicle. Do you understand what you've been charged with?
Yes, sir.
And this is in cause number 324-378-2. Now, to this charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Vincent, I'm gonna show you what's have been marked as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
And on page 2 of the same document, Mr. Vincent, are these your initials on the line that says no contender?
Yes, sir.
And on page 3 of this document, Mr. Vincent, is that your signature above the line that says defendant?
Yes, sir.
And on the next document, which is the trial court certification of defendant's right of appeal, Mr. Vincent, do you recognize this document?
Yes, sir.
Is that your signature on the line that says defendant?
Yes, sir.
There's 2 boxes that's checked at the top of this document. The first box states that this is a plea bargaining case and you have no right to appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving, which means you're giving up your right to appeal. Do you understand that?
Yes, sir.
Also, I have before me a document that is titled the Discovery Certification. Mr. Vincent, do you recognize this document?
Yes, sir.
And is this your signature on the second line of this document that's above the line that says defendant?
Yes, sir.
Now, Mr. Vincent, prior to signing and initialing all of these documents, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit Number 1. State, you like to offer State's Exhibit Number 1?
Yes, Your Honor, and I'd also like to offer State's Exhibit Number 2. That's the probable cause affidavit for this case.
Mr. Antoine, you have any objections? No objection. State's Exhibits Number 1 and 2 are admitted. Mr. Vincent, well, excuse me, Mr. Antoine, you have advised in counsel, Mr. Vincent, is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Vincent, your attorney, Mr. Antoine, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Okay, Mr. Vincent, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea of no contest and waivers were freely and voluntarily given. I will also find that there's sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement?
Yes, Your Honor, it's for 18 months deferred probation, an $800 fine, 100 hours community service, a theft class, and no contact with Drake Dalton furlough. Oh, and Your Honor, I forgot to also say that this is going to run concurrent with cause number 324380-2.
Okay. Okay. Mr. Vincent, the state is offering, in this case, cause number 324378-2, the state is offering that you serve 18 months deferred adjudicated probation. During the 18-month deferred adjudicated probationary period, you will be required to pay a fine of $800 plus court costs, which comes to a total of $1,092. During the 18-month probationary period, you will also be required to pay probation fees of $60 each month, a urinalysis fee of $15 each month. And you would have to be required to reimburse the county to court appointed attorney's fee. That says 125. Yeah, it would be 300. So that would be split, that would be 150. Right? Okay, let me do this again. The state is offering that you serve 18 months deferred adjudicated probationary period. During the 18-month deferred adjudicated probationary period, you'll be required to pay a fine of $800 plus court costs of $1,092. But plus court costs, which comes to a total of $1,092. Fine and court costs equal $1,092. You also be required to pay probation fee of $60 each month, a urinalysis fee of $15 each month, court-appointed attorney's fee of $150, and your total monthly installments in this case, what is it? It's gonna be about 150. Okay, it's gonna be $155 per month. You also be required to perform 100 hours of community service, and you would have to attend and complete a theft class, and you cannot have any contact with Drake Dalton Furlow. In this case, will run concurrent with clause number 324380-2. And if I didn't mention it, you will be required to perform 100 hours of community service, as well as adhere to the other standard terms and conditions of your probation. Now, Mr. Vincent, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Vincent, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Vincent, let's see, we'll move on to your next case. And your next case is clause number 324380-2. And Mr. Vincent, in this case, the information alleges that on about September 2nd of 2019, while you're in Jefferson County, Texas, that you committed the class A misdemeanor offense of you committed the class A offense of burglary of vehicle. Mr. Vincent, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Vincent, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charge?
Yes, sir.
Problem is getting to this document. Yeah, I'm having a problem trying to get into it. Okay, we are in clause number 324380-2. I have a document before me that's titled the misdemeanor plea admonishments. And it also states exhibit number 1. Mr. Vincent, do you recognize this document?
Yes, sir.
On page 2 of this same document, Mr. Vincent, there are a set of initials on the line that says nolo contendere. Are these your initials?
Yes, sir.
And on page 3 of the same document, Mr. Vincent, at the top of this document, there's a signature above the line that says defendant. Is that your signature?
Yes, sir.
And on the next document, which is the trial court certification to defendant's right of appeal, do you recognize this document?
Yes, sir.
Is that your signature at the bottom of this document?
Yes, sir.
At the top of this document, there are 2 boxes that's checked. The first box states that this is a plea bargaining case. You have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving or giving up your right to appeal. Do you understand that?
Yes, sir.
And I also have before me discovery certification. Do you recognize this document?
Yes, sir.
And is this your signature above the line defendant that says defendant, above the line that says defendant? Now, Mr. Vincent, prior to signing and initialing these documents, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me state's exhibit number 1. State, you like to offer state's 1?
Yes, Your Honor, and I'd also like to offer state's exhibit number 2. That's the probable cause affidavit for this case.
And Ms. Antoine, you have an objection? No objection. State's exhibits number 1 and 2 are admitted. Ms. Antoine, you advised that counsel, Mr. Vincent, is there any evidence that he's currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Vincent, your attorney, Mr. Freeman, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Okay, Mr. Vincent, I'll follow your plea bargaining agreement that you have entered into with the state. Well, Mr. Vincent, I will find that you are mentally competent to stand trial. I will accept your plea of no contest. I'll also find that your plea of no contest and waivers was freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement?
Yes, Your Honor. It's for 18 months deferred probation, no fine, 100 hours community service, a theft class, no contact with Drake Dalton Furlow, and that's to run concurrent with cause number 324378-2.
Okay, now, Mr. Vincent, the state is offering that you serve 18 months deferred adjudicated probation. During this 18-month probationary period, you will not be required to pay a fine. However, you will be required to pay court costs of $292. You will not be required to pay a probation fee because you're paying it in the other case. And you will be required to pay a urinalysis fee of $15 each month. And you will be required to reimburse the court-appointed attorney's fees of $150. Now that comes to a total of $45 per month. Mr. Vincent, will you be able to pay the $45 per month?
Yes, sir.
And Mr. Vincent, you will also be required to perform $100 of community service and attend and complete the theft class. And you'll be required, and you cannot have any contact with Drake Dalton Furlow. In this case, will run concurrent with cause number 324-378-2. And you will also have to adhere to the standard terms and conditions of probation. Mr. Vincent, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Vincent, I'll follow the plea bargaining agreement that you entered into with the state. Now, Mr. Vincent, in both of these cases that you received deferred adjudicated probation on, if you successfully complete the probationary period, this case will be dismissed. It will not appear on your record as a conviction, and you may qualify for a non-disclosure. You can talk to your attorney about the non-disclosure. Now, Mr. Vincent, we need you to stand on the X where your attorney is standing. You're going to follow the directions of the court clerk. And once you finish in here, this case, then you'll be excused and you have a blessed day.
All right, thank you, Your Honor.
Okay.
We're ready.
Mr. Wright, something?
Okay. We're back on the record in clause number 327554. And the case is styled the state of Texas versus Brandon Lee Hockless.
Yes, Your Honor.
And we have in court Mr. Brandon Lee Hockless. And Mr. Hockless previously was sworn in. Mr. Hockless entered his plea of nolo contendere, no contest. And I think Mr. Hockless had also acknowledged that state's exhibit, his initials and signatures on state's exhibit number 1, and his signature on the trial court certification of defendant's right of appeal, and his signature that was on the discovery certification. And Mr. Hockless acknowledged that he read and understood everything in these documents, and his attorney went over these documents with him. And the state offered to introduce state's exhibits number 1, which is the misdemeanor plea admonishments, and state's exhibit number 2, which is the probable cause affidavit. And defense counsel stated he had not read the state's exhibit number 2, and he needed time to read it and go over it with his client. Mr. Lawrence, have you read state's exhibit number 2, and then did you go over that with your client?
Yes, I did, Your
And do you
Honor.
have any objections?
Well, we just have one little exception. Mr. Hockless agrees with the rest of it, but he did, and I had discussed the situation, the incident with him extensively. And this coincides with what he had said before. He says he is innocent of having punched his wife, Brianna, with a closed fist on the left side of her face.
Okay,
He
well,
says he's innocent of that. The rest of it, he'll go along with his.
okay, well, at this time, Mr. Lawrence, I'm not going to accept the plea. At this time, we're going to just reset this case, okay? And then,
Your Honor, that's the only thing he has a problem with.
okay, but I made an allegation is saying that he was punching the complainant. I mean, I'm looking at the information. So obviously, if he's not pleading true, if he's not pleading to or no contest to these allegations saying that he's innocent, innocence means he's not guilty. So at this
Your Honor,
time, now you'll have an opportunity to talk to your attorney.
Let me explain, Your Honor. He can do a no law contendere
I
plea
understand that.
under North Carolina versus
I
Alfred.
understand he could do a no contest plea, but what my issue, or not the issue, but you said the guy just said he was not guilty. So you can't say I
Excuse me,
plead
Your
no
Honor.
contest, and you can't
Excuse me,
say
Your Honor.
I'm not guilty. I mean, these are two different pleas.
The U.S.
There are three
Supreme Court.
there are 3 types of pleas. One is guilty, one is not guilty, and the next one is no contest and no contender. So
Well, there's an exception to that, Your Honor, if you will read this case by the U.S. Supreme
okay,
Court.
let me do this here. I'm gonna take
My
that.
offer will be pulled. If he's going to say that he is innocent and that he did not punch, my offer is pulled.
Okay, well, so
I will offer this to the court to show you that he
okay,
can say
I
this.
don't. Okay, Mr. Lawrence, there are ways to present information to the court. Okay, you can file motions or whatever you need to file to do that. But at this point, the state is saying that they are pulling their offer. And at this time, if the state pulls this offer, there's no plea bargain. Okay, so at this time, we're gonna reset this case. You can submit whatever motions you need to submit, and the court will set these matters for a hearing. And so at this time, this case, the state is pulling its offer. We do not have a plea bargain agreement, and so therefore, this case is gonna be reset.
Your Honor, I believe I had submitted this to you for you to read for
Mr.
whatever purpose.
Mr.
Before
Lawrence,
the state did that.
okay, Mr. Lawrence, there are proper ways, as you are an attorney, a licensed attorney in the state of Texas, and there are ways to present information to the court. And in fact, whatever is presented to the court has to be presented to the state as well. So at this time, this case is going to be reset, and we will call the next case. Okay,
If I
Just-
could, Your Honor, if you would give her the citation, which
I
is on the
don't, I'm
case.
not going to give her, if, whatever you need to give the state, you can do that. Okay,
You can, I can give her the citation. You can, I would appreciate. The
Okay,
US
I know.
Supreme, let me
no,
explain
no,
to you.
let me explain something to you, Mr. Lawrence. This case is being reset.
Yes, Your Honor.
Okay,
But the
so,
US Supreme, the
Mr.
US Supreme Court
Lawrence.
says, Your Honor,
Mr.
that
Lawrence,
he can say he's
Mr. Lawrence,
innocent of certain things.
Mr. Lawrence, there are ways to present what you need to present to the court. And if you don't present it the proper way, the court don't have to hear it. And you're not presenting it in a proper way. That's all I'm saying. So at this time, Mr. Lawrence, the case is being reset and we're going to go to the next case. All right? And so this concludes this matter.
Your Honor, could I say one thing?
Mr. Lawrence,
Could I say one thing?
no, you cannot, Mr. Lawrence, just, this case has been reset. You need to, it's gonna be reset to give you time to present whatever you need to present to the court and the state, and then we can set it for a hearing.
I've already got the only thing I want to present right here.
Well, okay, well, you have to present it in a proper method. There are ways to